everybody, Zach Wolf here with another Top 5 Tuesday. Well, it's been a little while, but Top 5 Tuesday is back. And this week on Top 5 Tuesday, it's a timely one. It's my top 5 lessons from the Houston drive-through voting lawsuit. You might have heard about this lawsuit. Shortly before Election Day, a handful of Texas Republicans filed a lawsuit in federal court in Houston trying to stop the Harris County clerk from doing drive-through voting. Well, the judge in that case ended up dismissing the lawsuit, but there were some interesting lessons I think lawyers and others can learn from this case. Number 5 is don't assume the judge is going to rule based purely on partisan politics. When this lawsuit was assigned to District Court Judge Andrew Hanen, a lot of people on the Democratic side kind of flipped out because he is a George W. Bush appointee. He had ruled against the Obama administration in a high-profile case. He had a reputation for being a very conservative, partisan Republican judge. Now, here's the thing. Political views and political ideology certainly can have a role in how a judge looks at a case. But it's usually wrong and too simplistic to just assume that the Republican judges are going to rule in favor of the Republican position, or that the Democratic judges are going to rule in favor of the Democratic Party position. It's usually more complicated than that. That was certainly the case here, where District Court Judge Andrew Hanen, while he agreed with some of the arguments made by the Republicans, overall, he rejected their arguments, and his ultimate decision was to dismiss the case. The number 4 lesson from the Houston drive-through voting lawsuit has to do with seeking an injunction. This lesson applies to a lot of different types of litigation. The lesson is don't delay if you are the plaintiff asking for an injunction. In this case, the judge just thought that the plaintiffs waited too long. They had known about the drive-through voting plan for months, and yet they waited to file their lawsuit and to ask for an injunction from the court until less than a week before Election Day. The judge just thought they had waited too long, and when you delay that long, you are unlikely to get an injunction. The number 3 lesson is that the outcome of litigation can often turn on somewhat technical issues of procedure. In this case, the judge dismissed the lawsuit for lack of standing. Standing is a somewhat esoteric procedural issue. It goes to the question of whether the plaintiff has alleged some injury particular to that plaintiff as alleged to some more generalized injury suffered by the public generally. That sounds pretty boring, but a lot of times it's the boring issues that can make all the difference. That was certainly the case here. The number 2 lesson is the importance of the remedy. What do I mean by that? In this case, let's say, for the sake of argument, that the Harris County clerk's drive-through voting scheme violated the Texas election code. Well, the clerk's lawyers argued that even if that were the case, under Texas law, that does not necessarily mean that you throw out all the votes. No, that's a very harsh and drastic remedy reserved for only some particular kinds of cases. So you might have some technical violation of the election law, but that does not necessarily mean the plaintiff is going to be entitled to the remedy of throwing the votes out. This is a principle that applies in many types of litigation. There are often situations where the defendant might have done something wrong and might have violated some legal duty, but that doesn't always mean the plaintiff is going to get the remedy that the plaintiff is asking for. And finally, the number one lesson from the Harris County drive-through voting lawsuit is the importance of how you frame the issue. The core legal issue in the case was whether a tent, as in a tent used for drive-through voting, is a building under the Texas Election Code. That's because the code required that on election day, voting take place inside a building. If you frame the issue as, is a tent a building? Most people are probably going to say that a tent is not a building. But what if you frame the issue differently? What if you frame it as asking, should the court construe the term building in this particular election statute to include a tent, considering the purpose of the statute, the surrounding circumstances, the consequences of construing it that way, and taking into account the special circumstances resulting from the COVID-19 pandemic? That's a very different way to frame the issue, and one that obviously favors the defense more than the plaintiff. So, in many times in litigation, how you frame the issue is half the battle. Okay, those are my top 5 lessons. If you like this video, please hit the like button, or even better, share it with someone you know. If you agree, disagree, have a comment, please leave me a comment. And hey, thanks for watching.